Hey guys, David Phillips, attorney. We get asked all the time, can I bankrupt on my student loans? The answer to the question, unfortunately, is in most instances, no, that's not possible. In a Chapter 7 proceeding, most of the circuits around the country follow the Second Circuit case, which was the Bruner decision when looking at student loans. And they basically developed a three-part test to determine whether someone might possibly be able to discharge a student loan. And it's based upon the concept of undue hardship. In order for it to be considered an undue hardship for a person to be able to discharge their student loan, it would mean that you could not maintain a minimal standard of living and pay back the student loan. That, by the way, is a very minimal standard of living, and the court is basically there just looking at the really basic necessities of a roof over your head, groceries, something, food, water, electricity, that type thing, and very little else. So a pretty hard prong of the test to meet for most folks. Also, you have to show that this undue hardship will be continuing during the repayment period of the student loan, which means that it can't just be a temporary setback, meaning it has to be something long term that doesn't look like there'll be any real change in the foreseeable future. Finally, another big prong of the three-part test of the Bruner decision, you have to show that you made a good faith effort to repay the loan. This means that hopefully you had made some payments on the loan following graduation from school and whatever. And if you've not done so, well, then you will fail that part of the test and probably not be able to discharge your student loan. In the Middle District of Tennessee, where I practice, I am not familiar with any cases where our judges have allowed the discharge of a government-backed student loan. So that would be very unusual indeed. There may be some cases out there that I just haven't heard of, but in my research, it seems just almost impossible to discharge in Chapter 7 a student loan, and you do have to meet those three tests. And it seems like everyone seems to fail on at least one of the three parts of that test. That doesn't mean, though, that there isn't hope when you have student loans. Chapter 13 is an excellent way to deal with student loans. At the minimum, Chapter 13 simply will get the student loan people off your back for the 5 years that most people are in Chapter 13. You may not be able to pay a lot on the student loan during that time period, but at least the credit collections from the student loan people would stop during that time period. There has even been some recent cases dealing with student loans in Chapter 13 that may even allow the student loan creditor to be treated differently from your other unsecured creditors like credit cards, medical bills, and so forth. And this deals with some complicated issues regarding the best interest of the creditors test. But it is something that may be approvable in our district. Our Chapter 13 trustee has indicated he is going to look at those cases on a case-by-case basis to make a decision whether to oppose those or not. But everyone knows that something needs to be done to try to help folks. I believe the latest statistics show there's about 37 million Americans owe student loans, and approximately 30% of those are in default. So a major, major financial issue in the United States. Hopefully, we may even get some congressional assistance in the future on dealing with these student loans. But in the meantime, my recommendation would be to look very carefully to see if Chapter 13 might be of help. Hope that information is useful to you. Please give our offices a call if you would like to discuss this further. If you'd rather email, just go to our website, phillipsbankruptcy.com. Go to the contact section and give me an email, and I'll try to get right back with you. Thanks.